Good evening. Welcome to the Roadmap to Recovery workshop. We're going to be talking tonight, we're going to cover two topics, remedies for the underinsured and settling valuation disputes. We have some very special guests, and I'm really grateful we're able to make the time. As always, I'm very grateful to all of you for finding the time, finding the energy at the end of the day to come and absorb more information. And I, as always, United Policyholders does our best to make your time well spent and to give you information that is responsive to the challenges and issues that we either have heard from you that you're encountering or that we know you are probably encountering, just based on our 26 years of being in wildfire areas and helping people on the road to recovery. So we are a 501c3. For those of you who didn't know who we were, what we do, we're a charity. We survive on grants, donations, and a lot of amazing volunteers. First of all, the Tipping Point Community Emergency Relief Fund gave us a grant, which was fantastic. We were operating up here for quite a while without any funding, and it was a little scary, but we're on good ground to stick around here now for at least 2 years. The City of Santa Rosa, which has been a great partner for us. Sonoma County also has been a phenomenal partner. The California Department of Insurance, we've got Tony Signorelli, who's a deputy commissioner. I don't know how he does it. He lives in Southern California, but he has made it to most of our workshops to be here to help answer questions. So thank you so much, Tony. California Hope, which is a counseling service. They've got a table out front, and they are very anxious to make their services available to you. Hopefully, we will have somebody from the organization up at the end to just give a brief explanation of what you can, what services you can take advantage of. But again, they have a table out there. I want to thank Unitarian Universalist Church that has been our very comfortable sanctuary here to have these workshops. For a brief time, we moved over to the high school because we were filling this place up, and it just, I couldn't bear to see people stressed out, not being able to sit. But now we're back here, we're going to stay here. Our volunteers tonight, we've got Fred Booker, who helped you sign in. If you didn't sign in, we are doing our best to have a good mailing list so that we can keep folks informed when we're doing an event or co-hosting an event. So if you haven't been getting emails from us, please make sure to give us a way to reach you before you leave and by signing up. At the table, Fred is somebody who lost his home in Oakland Berkeley fire 26 years ago, and has it in his heart to be of service here. So, and then Keon Navari, who's a volunteer, first time with us tonight, and he actually does United Policyholders books. Is our finance manager, and he wanted to see what we're about. So thank you for volunteering, Keon. Again, we're a nonprofit. What we are, there's really nothing quite like us. We are a voice and an information resource for consumers of insurance in all 50 states. We have a 26-year track record and subject matter expertise in insurance. I'm a lawyer. I've never actually worked in the insurance industry, but my co-worker who's here tonight, Sandy Watts, actually had 2 decades of experience in the insurance industry. And United Policyholders really prides ourselves on our technical expertise. So our website, uphelp.org, has a library that is jam-packed with way more dry but useful information than you could ever use. But we always want to be better and do more. So if you are struggling with an issue and you've gone on our website and you haven't been able to find help, we want to hear from you. And you can email us always at info@uphelp.org. As I said, we're funded by donations and grants and a volunteer corps that has personal or professional expertise that's relevant to disaster recovery and insurance. The fine print, this workshop is intended to be general guidance, not legal advice. So even though I am a lawyer and I seem to have no problem spouting things that sound like legal advice, I'm not actually giving you legal advice. We don't endorse or warrant any of the sponsors listed at our website or the speakers at our workshops, although obviously we use as much diligence as we can to make sure that the people that you listen to, because we have presented them, or the people that you find because they've written something on our website or they show up, that those are good people. So we do our best. There's also our Ask an Expert forum, which is a way for you to ask questions and get answers from a lawyer or an expert in claim matters. And we do our best to assign the questions to our volunteer experts and sit on them to get you an answer as quickly as possible. Here tonight, you've got me. I am a policyholder advocate. That is my profession. Also a former bad faith litigator. So when I talk about the law on underinsurance, which I briefly will, it's because I used to represent people who were underinsured and take a run at fixing that situation. That is not what I do now. We've got Sandra Watts, who is a former 25-plus year insurance claim professional, veteran of many disasters, worked for State Farm and another insurance company, CIG, and is now doing two jobs. She's working for United Policyholders, and she also consults in mediation matters, which is the second topic we're going to cover tonight. We are very honored to have with us the Honorable Paul Beeman, who after retiring from being a judge, a sitting judge, he became a full-time mediator with a company called ADR Services. We're also very honored to have Sue Feeder, who is also a full-time mediator, and she is with another company that does mediation called Judicate West. They're volunteering their time, and I'm very grateful. We also, as I told you, have Tony Signorelli. We've got Kendall Jarvis, as I mentioned, with Legal Aid. And then I don't know if Gabe Osborne with the City of Santa Rosa is here. Gabe, are you here? Awesome. Thank you so much. And of course, we had Adrian Mertens out there, also with the City of Santa Rosa with the table, lots of good information. Okay, so we're going to jump right into the meat. This morning, I was up bright and early on the road and here in your fair city to be on a panel on a conference that was hosted by the North Bay Business Journal, talking about how is the community doing vis-a-vis rebuilding, and is it going slowly? It seems like it is it not? And they asked me to talk about the insurance question. And many of the people that preceded me on the panel were talking, they're in the construction business. And there's a lot of worrying rumors, as you know, about all kinds of things. But the reality is your recovery is not going slower than other recoveries I've seen by any stretch. I see you as being pretty much where we would expect, if not even in somewhat better situation, at least some people are. And that meaning with your insurance. Now, but that said, tremendous amount of underinsurance here. Our last survey, 66% of the people who responded said they do not have enough insurance on their dwelling to cover the cost of putting it back the way it was before the devastating wildfires. So while that doesn't come as a surprise to me, because that has been an obstacle to wildfire recovery since I co-founded United Policyholders in 1991. I mean, at Oakland Fire, underinsurance was front and center obstacle there, and even though we've been trying to reduce the problem, it's just very, very tough. And so a lot of you are struggling with the fact that you don't have enough insurance and you're trying to be creative and you also want to know what your options are. So we're gonna cover that as briefly as I can, and then we're gonna get into talking about dispute resolution through mediation. So remedies for the underinsured. Number one, find and use leverage and convince your insurer to pay above limits, okay? You may be able to convince them, and this is just informally, not through a lawsuit, that the fact that you're underinsured is their fault, not yours, that they gave you reason to believe that your coverage was adequate, and so you didn't do anything to fix it. You had no reason to try to fix it because they assured you that your coverage was adequate, okay? Or that you can establish that it was their mistake, their faulty underwriting, which is the fancy insurance word for before they sold you the policy, how they assessed you as a risk, how they looked at you and said, well, this person has these characteristics and we're gonna put a price tag on that. This person has a 50-year-old house, and that's underwriting. We're gonna charge them X for their assets. And if you can establish that it was their mistake, their faulty underwriting, you may be able to get them to pay over the contract limit. 3, if you can establish that they undertook the duty to tailor your coverage to your specific needs, that's another way that you can get an insurer to pay above limits. And then 4, technically in lawyerese, if you get an insurance company to pay above limits, sometimes they will do it on the basis of reforming the contract, that policy, to where it should have been. And that is often done where there was a mistake, where there is a mistake in their square footage, a big mistake, or a mistake in your address, or a mistake, something like that, where they will say, okay, we're going to reform the policy limits. Those are the ways that typically people can get an insurance company to do what they never want to do, never. The traditional line from your insurance company is always going to be, a contract is a contract, this is what it says, this is what you paid for, and we're sticking to it, right? So all the rumors that you hear about people getting paid over limits, sometimes it happens. It definitely happens. I mean, that is for sure. It usually happens confidentially. It often happens with the help of lawyers, sometimes with the Department of Insurance. But when it happens, it's because there were specific circumstances, okay? It's not, typically you're not gonna see, every underinsured State Farm policyholder get their limits reformed. That just doesn't happen without litigation. Okay. What are your options if you can't get any of that done and convince your insurance company to pay above limits voluntarily because you've convinced them that it is in their interest to do that, whether because they're gonna get sued and they're gonna lose, or because they're gonna look bad in the press, or whatever it is, whatever arguments you're able to marshal. If you're not able to do that, then you can, of course, file a lawsuit. You can sue an agent, broker, or insurer as an individual or in a group suit. Or you could sue another at-fault party if there was one. Okay, so just rolling back, and I'm going to tell you that those lawsuits are never a cakewalk. There's already one, at least one, I think there's probably quite a few, but the only one that I have seen is a group suit against USAA, and I'm going to give you the link to that. And the reason that the attorney filed that suit is that he believes that uniquely in the USAA policy language, the company voluntarily undertook that duty to set the limits. It's really, there's a lot of lawyer games that go on here. But anyway, let's go back. And so if you're underinsured, we want to walk you through 7 steps. Number 1, check your policy for obvious errors. Your insurer may have insured the wrong address or the wrong square footage. Next. Step 2, calculate the cost to rebuild as was what your home, so that you know what your home should have been insured for. Now, you've heard me on this stage, if you've been here before, you've heard other speakers over and over walking you through strategies, tools, techniques for figuring this out. If I were to rebuild that house, which of course we know hardly anyone ever wants to put back what they had, but that, generally speaking, is what the insurance company owes you for, right? Generally, it is always helpful to get that number nailed down, the as was rebuild cost, okay? So getting that nailed down, if I were gonna put this house back in compliance with local building codes, it would cost me X.
That is an essential step if you think you're underinsured, because thinking you might be is one thing. Knowing you are and how much you are is an essential step to figuring out what you're going to do next. Okay, number 3, review the history of how and when your dwelling limits were set. Did you remodel, refinance? Did you change insurers or agents? Did something trigger you to contact your insurer to seek that reassurance? Am I properly insured? Did you get reassurance? Can you prove that you got that reassurance? Again, these are tricky. Very few people can remember conversations or even have notes of why. But there sometimes can be a situation, again, the California law is your insurance company has a general duty. Remember, we've talked about this a couple times already. General duty to insure your home, but not a specific duty to make that insurance tailored and adequate for what you have. These are just some of the questions to get you thinking. How often did you speak with your insurer or agent, or did you buy your policy online? What, if any, specific conversations do you remember? How did your insurer or agent explain your coverage? Did you fully cooperate with all requests for information? If your insurance company wanted to come out and inspect, did you let them come out? Or did you say no? Did you ever refuse a recommended increase in coverage? It's common. It's, you got to be honest. If you did, if your agent said, listen, I don't think you have enough coverage and you ought to increase it, and you said, no, I don't want to, well, I wouldn't try to push too hard on that, because that's going to be probably a loser, okay? Similarly, if you went to your insurance agent or broker and said, this premium is just really seems awfully high, what can we do to decrease it? And that if you had if you cut out essential coverage, again, you're going to have a tough road. Did you notify your insurer of major improvements or remodeling? All right, we talked about that. Step 4, if possible, seek out and compare notes with other property owners who are or were underinsured by your same insurance company or agent. We've got Vita Eskander here. I hope I've said your name right. Where are you, Vita? Did I say your name right? Close enough. Who is hosting a very useful online resource where people are organized by insurance group, just like we've been facilitating that with our signs. We're not putting the signs up anymore because Vita's doing such a good job at getting people together digitally. If others got your agent or insurance company to retroactively increase their limits, find out what evidence and arguments won the day for them, if you can. You've probably noticed that some people among you that were active have sort of disappeared, and chances are they may have reached a confidential settlement with their insurance company, and the insurance company said to them, we're going to pay you over limits, but you cannot share this information because we don't want other people thinking that they're going to get the same deal. So it happens, that's life. Okay, step 5, make a clear written demand that your insurance company and or agent or broker honor the promises that were made to put you back where you were before the loss, go up the chain of command, and take all steps necessary to enforce that demand. We have a sample letter to help you with that. Let your insurer know you're underinsured through no fault of your own, and this is really important. Tell them how much you're underinsured. Tell them the exact amounts. Provide them with the documentation. And if your insurer responds by sending you a written questionnaire with questions that get at how your limits were set, see step 6. Consult with an experienced policyholder attorney, ideally before you let your insurer interview you, or take a recorded statement, or examine you under oath, or any of those things. Because whatever you say about that history of how those policy limits were set is going to affect whether or not they will bend the rules or they will go outside the contract. And then to find an experienced policyholder attorney, you can start on our website. We have a find help section. There's a map. I suggest you go to California. There's a long list of lawyers, and all they do is represent people in insurance matters on the policyholder side. And they support our organization. But I do want to be clear, getting an insurer to pay more than their contract says they owe you is not easy. And many of you can and should make the decision that if you don't have the facts in your favor, then you don't need to waste a lot of time and agony about it, and you just need to find other strategies. That's just the reality. But I always want people to take a shot. Take your best shot. Don't give up before you have done that, right? Because although the insurance policy is a legal document, there are invisible terms inside of it that our laws add to make sure that your reasonable expectations get delivered on, right? So every insurance policy sold in this state has an invisible clause that the insurance company has to be fair, act reasonably, which in the law is called good faith, right? That they have to treat you fairly. They're not allowed to deceive or mislead you. They have to live up to the promises they made. So some of the lawsuits that have been brought on behalf of underinsured people have been fraud lawsuits that have said, well, look, you defrauded me because I thought I was fully covered, but turns out I wasn't. Okay. Step 7, when UP conducts a recovery survey, participate. We just finished our 6-month. We're going to do another one at the 1 year. Please, when we do those surveys, please take them. It's very powerful data that we gather on this problem, and we are gonna solve this problem together. So no matter what, file a complaint with the California Department of Insurance. Keep your complaint simple and general. Don't go into too much specifics about your dealings with the agent broker. Identify your company and the approximate amount of the shortfall. They need to know what's going on in their market. So yeah, and just before we get out of the do-it-yourself negotiation remedies for being underinsured, I'm going to review best practices with dealing with your insurance company. It seems like I know anyone who's been here before has heard all of this, but I'm just going to, one more time, probably not just one more time, probably every time, we're going to remind you. Keep it professional in your communications. Be concise and to the point. Bold or bullet point your specific requests. Avoid long paragraphs. Use good grammar and punctuation. You're a force to be reckoned with. Promptly respond to letters and reasonable requests. Point out unreasonable requests. Common sense stays on your side. Avoid venting frustrations and emotions to your adjuster. Well, okay, that one, definitely avoid venting, but I don't expect anyone, and in fact, I hope none of you will roll over when you're not being treated fairly. I am hearing about terrible stories about people dealing with 5, 6, 7 adjusters and having to start again, and each adjuster seems to be handling things differently. It's not acceptable. It's not legal. There are all kinds of regulations that are designed to protect you, so you've got to enforce your rights, and if you lose your temper sometimes, that is normal. But we're trying to make peace here. So aim for an agreed upon scope of loss, right? Before you go down the road of litigation or anything else, even mediation, you must try to get on the same page with your insurance company over the scope. And when I say scope, I'm talking about quantity, quality of the home that was destroyed. I'm not talking about prices. I'm talking about the description. When we talk about the apples to apples, and we've talked about Xactimate estimates and how a lot of insurance adjusters these days will give you that nice, fat, fancy looking estimate, and it doesn't look anything like what a real life builder gives you. And that makes it very hard to know, okay, well, if the insurance company is saying they owe you X, and the builder is saying that they really should be paying you Y because that's what it's going to cost to put that house back, you need a scope so that the pricing can be compared apples to apples, and you can see why the numbers don't add up. Is it the drywall? Is it the quality of the wood? Is it the amount of the carpeting? Whose scope is off? Okay, aiming for that is really productive no matter what path you go. An in-person meeting with an adjuster can be very productive. I know it's easy to say and maybe harder for some of you who are dealing with adjusters in Texas or wherever, but again, your insurance company has a legal duty to adjust your loss fairly under the laws of California, and that includes working with you to get a resolution of your claim. So you have every right to request an in-person meeting. And your contractor or sub or whoever, whatever consultant or whoever is helping you with your rebuild as was number, that person needs to be able to speak contractorese and stand behind their numbers and explain them. So when you have this in-person meeting, the person or people that are helping explain why you're right and they're wrong, it will be articulate and know what they're talking about. And then try to figure out the areas where you differ, right, and why. And that is just very practical. So I'm going to turn over the microphone to Sue Feeder and the Honorable Paul Beeman.
I'm Susan Feeder, and I am a full-time mutual, we call ourselves, a mediator. In my prior life, I guess, I was a litigator, so I handled lawsuits and defended and prosecuted them. And then kind of realized that it was time to stop fighting, and maybe after raising 3 kids, that that's more fun to try to bring people together and resolve disputes. So mediators are people who try to resolve disputes, whether they're lawsuits that have already been filed or, as we heard, pre-litigation matters. So I work for a company called Judicate West. I do personal injury cases, I do real estate cases, I do all kinds of disputes, commercial and business and everything but family law. And I really enjoy it. I find it really rewarding. And I've been doing it for about 10 years. Thank you.
Hi, I'm Paul Beeman. I live in Vallejo. I was an attorney for over 26 years, and I was a judge for about 2 months shy of 18 years. And I was in the civil assignment for 12 of those years, and an additional 2 years as the presiding judge. I retired March 5th. I started working for ADR Services April 9th. And I do what she does. I mediate cases. The idea of trying to settle your case short of litigation is a good idea, not a bad idea. But before I delve into this, I mean, each of us could talk about this for 3 or 4 hours, and I think we're looking at something like a half hour. How many people in the audience are currently represented by attorneys? Just a few of them. Okay. The reason I ask that is I hate to see people taken advantage of. And a good attorney can prevent that from occurring. Does that mean you need to rush out and get an attorney? No. Everything that's being suggested here is good advice. I never heard of this organization until they contacted us to ask me to come up here and speak. And I spent a couple hours on their website, and I suggest you do the same thing. They have a great deal of smart, intelligent, good information. And if you want to kind of prepare yourself to be on to narrow the gap between yourself and a professional insurance person who spent their life in the industry, read about it. And like they said, if you have a specific question you don't know the answer to, submit it to them. Get prepared. Prepare. You can consult with an attorney without making that, have a long attorney-client relationship. You can get advice on how to prepare for mediation. I'm going to stop and give her a chance to talk a second. Go ahead.
Thank you. And I was just going to say, how many people think they have an idea of what mediation is? It's not meditation, just to be clear. I've often had it confused of what mediation is. Just show of hands, people think they know. Okay, I'm going to tell you what it is and then see if you're right. So what it is, number one, it's voluntary. It's a voluntary process. No one is ever forced into mediation. Both sides have to agree. And that's good because if both sides are invested in it and both sides agree to it voluntarily, put themselves into the situation, they're more likely to try to come to a resolution. So that's the first thing to know is it's never forced on anyone, it's only voluntary. And what does a mediator do? A mediator doesn't act as a judge. There's a difference between what we call mediation and arbitration. Mediation is where the resolution of the dispute is in the parties' hands. The mediator is really there just as a facilitator. We are not there to give advice along the way, but we're not there to tell anyone what they should do or shouldn't do. We're there to listen to one side and kind of repackage what we hear in one room and then convey it to the other side and try to get them to come up and then take what they're they're saying, go to the other room, and try to get one side to come down. So we're sort of starting out here with both parties and trying to get to here. And really trying to help the parties themselves come to a number, not that they want necessarily, and maybe not even what they need, but a number they can live with. And when you walk into mediation, you have to realize that you're going into compromise. The insurance company is maybe going to pay more than they set out to in the beginning, and the homeowner maybe is going to take a little less than the perfect number, but you're there to get it over with and resolve the dispute, and to kind of take the matters in your own hands, rather than going to court, being involved in a lawsuit, where a judge, a jury, an arbitrator, another person will be making that decision for you. So the difference between mediation and arbitration, you hire someone like Judge Beeman, a retired judge, and they act as a private judge. You bring your evidence, you bring your witnesses, you put on a little mini trial, and both sides are saying, we agree to waive our right to sue. We're going to tender this dispute to a private arbitrator who will decide the case and say, you win, you lose, you pay that person X amount. Mediation, it's in your hands, and you're the one in charge. It's a self-determined process where you're in charge of the outcome. And the one other thing I'll say is one advantage of mediation is that the whole process is confidential. It's like the Harry Potter cloak of invisibility. It's kind of a cloak of confidentiality. So you go through it, you spend however much time you agreed upon in advance, 2 hours, 3 hours, 4, whatever. You don't settle it. Whatever numbers were exchanged, whatever offers were made, it's off the table. You can't talk about it. No one can ask the mediator what the numbers were. You've explored it. If it doesn't work, you sort of know worse for the wear, and the whole process is kind of shrouded by confidentiality. So those are sort of the key things. It's voluntary, the person is a neutral who conducts the mediation, and it's confidential. And really, a mediator is not allowed by law to give legal advice. So if you walk in unrepresented by a lawyer, the mediator doesn't want to see anyone treated unfairly, but we are not allowed to say, this is the law and this is what you should do. Listen to me. That's going beyond the scope of what a mediator is supposed to be doing.
The mediator is not your attorney. Just bear that in mind. The point about confidentiality is spot on. It's a big difference between litigation and a settlement conference. It's shrouded with additional legal protection. The rules of evidence don't apply in mediation. But the thing I want to emphasize to you, since it's probably the first time for most of us, is we want to put together an intelligent, clear, simple, written mediation brief. You want to have corroboration. I mean, the house burned down, probably all your receipts and photographs and everything's gone. But you can look for, see what your realtor has. See what your preliminary title report, the title company says about your property. If you're dealing with the home itself as opposed to personal property. Look at credit card records. Look at MLS results for 2 years prior to your fire. Go look at your Santa Rosa paper and see what places were selling for in your neighborhood at the time of the fire. Talk to your neighbors. The information that was put up here for you earlier, I think will be on the website. Go over that again. It's great information. The idea that you would get together with other people that are negotiating with the same insurance company and become educated and exchange stories of what's going on, that's great. But now back to your brief. You want to get your brief in early. It has to be a good brief. And so the reason I want you to get it in early is because insurance companies are large corporations. You send it to somebody here in Santa Rosa or Sacramento, well, they're going to send it to Omaha or Great Bend, Kansas, or someplace all in the country. It has to be reviewed by panels. People have to give the individual who's coming to the mediation authority in advance, and you're going to play hell going above that authority. So good brief for them to evaluate, corroborating evidence. Keep it businesslike. Try not to get emotional. And this has been pointed out before, you can always walk away. You can always have a second session of mediation. And you have control of mediation. The one thing I used to tell people was, in a in a mediation or a settlement conference, you have control, like 50% of it. You're in charge of your aspects of it. When you step into the courtroom, you've absolutely left certainty out in the hall. Just because you think this is the way that the rulings are going to be, or what an appellate court's going to say, don't bank on it.
And so what happens in mediation? You have a day, you picked a mediator. Who's supposed to be there? I mean, you need to be there. If you happen to have a lawyer, your lawyer would be there too, but you don't have to have that. Bring with you whoever you might need to make a decision, whether it's a spouse, a co-owner of the property, any expert, person, your contractor, someone who can give you advice. There's no rules, as the judge said, no evidentiary rules. There's no problem with bringing your support person or your knowledgeable person with you. And then I think people think, I'm going to be talking to the insurance company, I'm intimidated, they know more than I do. Generally, most of the negotiation's done in 2 separate rooms. You may be together for part of the time, but it's informal, it's somewhat casual, no one's taking notes or records. So you're in one room talking to the mediator with your people who you brought, and you're sharing your information, you're giving them what you have, you're telling them your positions, you're again, it's all confidential, so you're really saying, this is what I want, that I would take this. You're being very candid, very honest. And then the mediator is the one who moves to the other room, and who's in the other room is whichever representatives of the insurance company they have decided to send. So one really great advantage of mediation, we were talking, I think on the board there, was have a face-to-face talk have a face-to-face negotiation with the adjuster. I'm sure, I know we've all done this, it's very frustrating to find the right person. It's hard to get them to return their calls. They're swamped too. So at least this is an occasion where they're forced to be there. They've chosen to be there, it's voluntary, but they're there. So you've got a person there who theoretically has authority. The company has sent them as someone who has a certain amount of money they are authorized to pay. So you at least have everybody in the same room. And if everybody's in the same, not room exactly, same building at least, maybe it's different rooms, but everybody physically there, it gives impetus to try to come to a settlement. So that's, one advantage. It's generally, it's almost always cheaper than litigation. It's faster than litigation. And of course, you have the control, control over it. And as the judge also said, the key is really being prepared. Walking in, having what you need, knowing all the facts you need to know. And now that I hear there's legal services, there's lawyers who, I don't know if they're pro bono, get the advice of a lawyer beforehand. Know, what your particular company has been doing recently, what have they been paying, what have they been doing with loss of use, how have they been evaluating contents. Do some legal research, and either with an attorney, do some research online into the industry. I think there's databases of how different carriers are handling different things. So the more prepared you are, the better, and know your facts. And then you walk in, and as I said, you may never actually, you'll have a small face-to-face, but you may be just dealing with the mediator, passing along your needs, your concerns, etc. And that person will share them with the other side. I see a are we supposed to ask questions?
So we are definitely going to have questions. Take questions, and if you wanted to, you want to wait. You normally wait to the end, but I am very anxious to let people take advantage of your expertise. Okay.
We can go ahead. We can take a few questions. We want to make sure that the questions that we take are sort of more general for the whole group and benefit everyone. So do we have a sort of a general question? And then we'll do a regular Q&A at the end. So
it's just in regards to what you mentioned just a few minutes ago about the insurance company sends their adjuster out to represent them, be here for the company, and then you mentioned that they send them out with a certain amount of money that they sent them to go there with. So why would they have a certain amount of money set before they've actually heard the mediation?
So what happens is when they get the information from the policy holder, the adjuster gets the information, the adjuster has their information, you're trying to reconcile it, and if the parties agree to go to mediation, what they do is they do an evaluation that's sort of a range of where they could see it going. They kind of look at your case and they say, okay, well maybe they're right here, maybe, so they get a range, and they usually to take something over what they have offered you, because if they're not going to offer you more than they've offered you, there's no reason to go to mediation. So you can expect that when they come to mediation, they have more than they've offered you, because it's an attempt to settle the claim. So they have to come up with an amount, and so they kind of agree, okay, well, we're going to put X amount, we're going to let this adjuster negotiate up to this amount. So each adjuster has what's called a settlement authority, and a lot of them have a specific amount that they have all the time. You don't have to ask, then there's different levels, and you have to ask different people as to know what the scale.
Go ahead. No, you go ahead. I've talked a lot.
One thing I want to point out, I think you might have picked it up in some of the slides, but I would like to emphasize this about 25 times, I'll just do it once or twice. And that is that you, in your relationship with your insurance company, you are first party. You're party to that contract. They owe you the fiduciary duty of treating you fairly and in good faith. As I mentioned on the website, you go on the website, you look up in Insurance Code Section 790.03H or D, whatever it is. They set out like 2 pages of duties and obligations that your insurance company has to you. I mean, it's not like you were in an automobile accident with someone and that third party is suing you. They're a stranger to the contract. Your insurance company, other than complying with the state insurance code as it's enforced currently, they don't owe them a fiduciary duty. A fiduciary duty is the highest in, they owe you the duty of loyalty, they owe you the duty of professionalism, and not just represent the truth, and not knowingly under-evaluate your claim. It's you. The idea that it's first party, you should be in the forefront of your mind.
Exactly, and even as your insurer and in a first-party claim, they have to hold your interests equal to those of their own. So they have to treat you as they would themselves. That's their duty, and they well know that they can be sued for bad faith if they don't do that. So you can, they can't jerk you around. I mean, they're not supposed to. They can't. They can try, but they're not supposed to. When you go to mediation, again, as you asked, why would they come if they've already decided how much they're going to pay? They have a range, as you were saying, and the role, the kind of the job of the mediator is to find out how much is what they say, at least, is the most they're going to pay, and then get them to pay a little bit more. And same things, we're neutral, we're not on either side. In your room with the homeowner to find out what we say is, my God, I have to get this, I can't do it if I don't have more. And then just try to see if you might take a little bit less, knowing that this is the most that they're going to pay. So we're really trying, again, you have to come with flexibility. You have to come knowing that maybe you won't get as much as you maybe would get on your best day if you went to court, but you're going to save a lot of money, you're going to save a lot of time. You're going to save aggravation, you're going to get your money quicker because this whole process can be gone through quicker. And, the peace of mind and just having it done, having a sum of money is worth something too.
The other point, I mentioned you gave your brief and for your mediator needs time to read the brief, your opposition's brief, and understand what the differences are. And there's nothing unethical in the world about you picking up the phone after, say you send it in 14, 15 days, 20 days in advance. You pick up the phone, you call the mediator and say, hey, have you had a chance to read it? Do you have any questions? Anything that I left out? Is there any more information I can provide? So what you're trying to do, you're trying to front load this thing so that you get the mediator in the best position to be prepared. You're trying to get as much work done before the date and time of the mediation, because you don't want to get there and somebody forgot a document. There's just so many things that can be missing. You want to have everything available right there for the mediator so that you don't hit a snag. Now, if you do hit a snag, the world will continue to rotate. But you can come back, you can do this again. Many mediations are settled over the phone after the in-person meeting has completed. People, they narrow their differences. They're not there yet. They talk over the phone. It might take 4 or 6 weeks. They narrow the differences. They get to the point, I used to tell people it's kind of like magnets when you were a kid. Now you take the magnets out here like this, what in the world are you doing? Nothing's happening. You start bringing them in, nothing's happening. You bring them in a little more, hey, I'm not so sure something might be happening. You get about to right here, whoa, they come together. That happens in mediation and settlement conferences all the time. Another point about mediation, how you conduct yourself, listen, and when you're asked a question, try to give an answer that is directly responsive to the question. If you have an explanation afterwards, fine, but initially, answer the question.
And some of you might be wondering what's going on now. What would this mediation look like? I mean, it's not free, it's not, you negotiate on the phone with your adjuster, and that doesn't cost anything if you can get them to listen to you and answer the phone. If you have a mediation, and I think what is being hopefully thought of is some program whereby maybe insurance companies will agree to have multiple mediations in a day and either share the cost or cover the cost themselves. I'm thinking that a program possibly would be started. If not, you could suggest, if you've been negotiating with your insurance company and you're still quite a ways apart, you could suggest, I've heard about this this practice called mediation. I'd be willing to go with it. You could ask them, would you be willing to pay the cost? I mean, put it out there and ask if they would. They're more used to it. They're used to paying mediators' fees. And often what they spend on defending a case or on a mediator is not in the same pot as the money they spend and they pay out on claims. So they may be more willing to pay for mediation and not have that kind of cut into the amount that they'd be willing to pay you on your claim. So I would say if you broach the topic with your adjuster, if it seems like you're just at loggerheads and not able to resolve, come up with an amount, suggest it and, see if they agree, and then kind of the icing on the cake say, and by the way, how would you feel about paying for the cost of mediation, and see if they'll agree to that. It doesn't hurt to ask, certainly.
As I figured out what we're going to be doing here tonight, or got closer to figuring it out, I called a friend of mine this morning, Steve Delaney. He was the judge in San Mateo County that presided over all of the PG&E litigation down there in San Mateo out of the explosion. Now that case was much smaller than what exists up here. There were 528 personal injury cases. There were over 200 subrogation cases. Separate and apart was a stockholders derivative action. In the PI cases, there were 8 deaths, over 50 serious injuries. Now, one of those cases went to trial, okay? They were all filed lawsuits, but not one of those cases went to trial. And what they did was, the defense counsels as a group got to pick 4 mediators. The plaintiff's attorneys as a group got to pick 4 mediators, and they mediated the case. They had many repeated sessions, and the entire litigation was concluded without one single trial within 3 years. And your problem is bigger. It's more complicated. But a couple of the causes of action are going to be kind of drifting out of what you wanted. But I'll come back in just a second. It's going to be inverse condemnation. Without going into all the details, inverse condemnation against PG&E is very much akin to strict liability. And so what's going to happen? At some point, your insurance company is going to settle with you. Okay, well, that's fine. You've got that aspect of your problem taken care of. But what's going to happen is your insurance company is going to step in and then sue PG&E to get reimbursed. So don't feel so sorry for your insurance company.
I wonder if they do. I'm not sure.
I don't
The mediation is a very good one. You can write it off. It's a business expense. That's their business. And you can't write that off.
Exactly.
And then the idea of attorney's fees. Now, I want to mention this. There are many ways in a condemnation action, I'm missing another, in the condemnation action, where attorney's fees can be recoverable. Not always, but the overwhelming majority of times. Plus there's prejudgment interest. But back to mediation. It is a good process. You're making a mistake if you don't try it. And the more help that you get in getting prepared, the more likely you're going to be satisfied with the results.
My husband's a plaintiff's personal injury lawyer, and actually he had one of the 8 death cases and mediated in front of Judge Delano.
Your husband, John?
John, yes. So he had one of those cases, and yes, was resolved in mediation, and each case kind of got settled along the way. But, you know, those are different cases, those were against, not people's own insurance companies against, so it wasn't that first party that the judge was talking about, it was third party against, you know, and in these fires, there's also ongoing litigation currently against PG&E, which would be a third party case, so different than the claims that all of you have. So there's a lot of levels, a lot of facets of this whole tragedy.
So, yes, there are a lot of levels. So what we want to kind of go through a few things we have and talk about what we mean when the dispute, a couple different things. When you choose to go to mediation, you've got to really have a clear delineation of what your subjects are, what you haven't where you pay there. But what are your areas of dispute? Is it straight money? A lot of insurance companies, you know, I talk to some people, a lot of insurance companies are going to be a little hesitant to do the underinsurance thing in the mediation. It's always good to ask, but that's something, it's a little tougher thing than a valuation dispute. So you need to be really clear on which part of the claim you're going to mediate, because it is possible to mediate some parts and leave other parts open. So if you say, look, I've got to settle it now, but I still have an underinsurance issue, you can always go to your insurance company and say, okay, can we work it out for the policy limits now, and then we can talk about, we can leave the underinsurance issue open. So there's ways you can leave certain issues open and mediate other issues. So don't think it has to be all together. And then I want you guys to talk a little bit about making the dispute right, how to make sure that you're ready to go. Because in my experience, one of the reasons mediation breaks down sometimes is because they get there and one of the parties isn't ready. So if you could talk about that a little bit.
Yes, right, meaning, you have what you need, you have the facts that you need, you have the documents, you talk to experts, and you know how much it's going to take. You've got plans for your building, you've got enough facts to develop the evidence to a sufficient degree. Sometimes they get overripe, like fruit, meaning if you're involved in actual litigation, if you have a lawyer and you've gone so close to trial and you've already spent so much money, then people are like, you know what, I want to just go through the trial because I've already spent a lot of money on this case. So there's that fine line between being ripe enough but not too ripe. In your cases, since most of you don't have lawyers, you haven't really gone through litigation, it's the risk of being overripe isn't too high. But it's just, the more ready you are, the more you know exactly what you need and how much it's going to cost, and to come there and find out that I don't really have an estimate yet, this contractor hasn't got back to me, the flooring guy is still out there, I'm not really sure. That's too many question marks left open. The insurance companies think this isn't going to really be resolved. We really need to know that it's more your work that you have to do, and have to advise share with the insurance company what you're going to present. Again, no secrets. Sharing is better. You're asking them for money. It's money they owe you, but you need to give them your ammunition.
I agree with everything you said.
I'm so glad.
There shouldn't be any unknowns. If you have an unknown, you're not right. You're not ready. You know what it is you're seeking. You have corroboration. You have provided it to the other side so that they can justify paying you the money. If you have justification for half of X, you think they're going to give you the other half without any proof? They're not. You have to be prepared. Another thing I would ask that you consider would be this, is that, let's say you go through this mediation process, you try your guts out on the thing, you've done it 1, 2, 3, 4 times, and you still feel like, you're getting a raw deal. Not that you're just a little bit apart, but you're getting a big, raw deal, okay? File a complaint with the California State Insurance Commissioner's office. Make it happen. If you don't have the documents in there, they can't point to a large group of people that are being taken advantage by insurance companies to then push for reform, to prosecute them, to do something about it. You remain silent, that's on you. Don't do it.
We answered that, the right question.
Yeah, so we just want to run through the pros and cons here, and then we'll wrap this part up and we'll take questions at the end. So just some of the pros to mediation. It is a relatively inexpensive alternative. You're not bound by the results, and it's a very efficient way. And even if you don't settle the case, it does sort of get the parties. It's like, well, now we're very clear on what our position is and on what the insurance company position is, and that can be a helpful thing moving forward. The cons, I think in cases with you guys, it's going to be largely upon you to try to convince your insurance company to take this avenue, especially to try to get them to pay for it, but they should be willing to do it. It's cheaper than litigation. Mediators would never inappropriately discourage or scare a policyholder. That's just in there. But sometimes, one of the things that happens, they don't give legal advice, but you should listen to the mediator, because sometimes, they'll tell you, hey, look, this is what I see as your problems. They're telling the other side the same exact thing. So they're saying, here's what I see as weaknesses in your case, and they're in the other room telling the insurance company, here's what I see as a weakness in your case. There is a confidentiality agreement between the mediator, so they're not supposed to tell the insurance companies things that you ask to keep them secret. And that's one of the reasons why, if you do choose the avenue, you want to choose a really professional mediator. There's a lot of community mediators, and they're great for things like family law and neighbor disputes, but something like this, you'd want a professional mediator. And then the big disadvantage really on this is that the insurance adjuster does this all day, day in, day out, and you do not. So that's one of the sort of disadvantages to taking this road, but it's the same as if you're negotiating with them on your own anyway. So it's not like they're going to find out something that's going to harm you later. These are they're complicated, but they're also fairly straightforward. It's not something where anybody's hiding anything. The cards are all out on the table, and it's trying to reach an agreement. So,
Can I say something?
Yeah.
Back to the idea that this is first party. When you get their brief, they're educating you. You can see the breakdown, the substance, the parts, the pieces of what they assign to your different items that you're claiming. And you can see, in some cases, maybe your insurance company's right and you're wrong. But at least you can see what their position is and find out what the differences are to try to find out who's right, who's wrong. The other thing, as being first party, you're entitled to a copy of your claim file. You're entitled to everything they're looking at to make the decision on how to evaluate what to offer you. So don't let them hide that from you. Make a demand, make it nicely, make it in writing, do whatever you have to do, but they need to give that to you so you can make sure that 2 + 2 = 4.
And the one thing I would point out about if you don't like the result, you can walk away. Even though the mediation process is voluntary, once you actually come, there really, if you don't like the result, if you don't like that final number, then there really is no result. I mean, you're walking away because you haven't reached an agreement. So eventually, if you do come to a decision, come to an agreement about something, you sign an agreement. So the end result of the process is something final, and you would be bound by that agreement. But again, with your agreement, you voluntarily embarked upon and signed. So walking away, I thought that might be a little bit confusing.
That's good.
Walking away from it. Yeah. You can't sign it and say, you know what, I changed my mind, I don't really like it.
Yeah, the idea is, they give you the document to sign, say, okay, I want to take this with me, I want to have a lawyer look at it, I'll get back to you. You don't have to have a gun to your head, you don't have to sign it right then and there, because you want to be sure what it is you're releasing them from, what it is you're waiving, what it is you're forever giving up. Don't make a mistake.
Yeah, I would say, even though, why does it keep doing it? even though you don't have a lawyer with you at the mediation, I think it's a really good idea to just have someone review the agreement before you sign it, if you can. You have a lawyer you're consulting with on, you're not paying to be there and sit there with you for the 4 hours of mediation, but someone to look at, because again, once you sign it, it's now a binding contract that is now taking the place of your insurance contract. So have a consultation counsel that you look to, whether it's a friend or someone you hire, spend an hour looking at it, at the agreement, the proposed agreement, before you sign it.
You can ask your insurance company, hey, you know, if we enter into an agreement, you're gonna want me to sign some kind of document. Why don't you give me that document in advance so I can look it over? So, you know, 7, 8 days in advance, you've already read it, and you can see where they're trying to head this thing. And you know what to be cautioned about, and what's acceptable.
Any other questions, Mary?
So, let me tell you what we're gonna do, because this is sort of unfolding. Why don't we have you guys sit for a few minutes, let us have our other two folks explain their options. Be careful. And then we would love, please hold on your questions, and we are definitely gonna make time for them. And my goal, even though everyone here doesn't seem to mind that there's a Warriors game on, I do want us to get done on time, but I do want to make sure we get all the questions answered. Okay, so you might be wondering why are we sitting here listening to something about a process? It's because we think mediation could be great, a great way of getting you guys out of the log jams a lot of you are in. And United Policyholders is very much working to try to create a pilot program here for you as an option. But we are really at the early stages, so we wanted to first sort of expose the community to the concept and get people thinking, and then really ask you if you're interested to shoot an email to sandy@uphelp.org. Because we have approached some insurance companies already, there is some interest. So again, there has to be some interest on your end as well. Because the processes it has to get structured, somebody has to pay for it. If you're interested in a mediation pilot with your insurance company, you can send an email to sandy@uphelp.org, and then we will be continuing to disseminate information and build support. We are working on it. It's a very early stage.
And I think it would be good if you sent me an email I'm sandy@uphelp.org, but if you send me an email and let me know who your insurer is, and just a teeny tiny bit of what your dispute is, just so that we have an idea of what companies we're having to deal with, and then what are our major sort of disputes that could be dealt with in the
Thank you. So, okay, we're going to quickly bring up Tony Signorelli, who's going to explain to you an option that his agency offers. We're going to bring up Kendall Jarvis just to give a quick perspective from somebody who used to be a community-based mediator, and then we are going to take the questions.
Thank you, Amy. Good evening. I'm Tony Signorelli, Deputy Commissioner over Consumer Services. I just wanted just a couple things. We've been out here for almost all these meetings and other meetings. We've had our own workshops, but mediation. So we have a mediation program too. So I want to explain that. But before you do mediation, as the judge said, come to us because we have a free service. We have 100. They're called compliance officers. They're on staff. And they have insurance experience. All of them come with an industry background. They're trained on all the laws and all the regulations, and we have a pretty good success rate. We get about 40,000 complaints a year. We recover about $50 million a year for consumers on a case-by-case basis on all auto, homeowners, life, health, all kinds of insurance. Just for these, just for the October wildfires, we received about 400 complaints so far, and we recovered about $40 million just for that alone, just for that even alone so far, and additional funds and insurance proceeds to insurance companies. almost all of that on the claims end right now, but we have had some substantial recoveries on the underinsurance issue. It is the most challenging issue, as which was mentioned earlier, but it is an issue that if we do find flaws or violations of how the insurance company processed your application, gave you a replacement cost estimate, or other factors, we may have some ammunition to get the insurance company to either reform your contract or increase your coverage, and that result getting you more coverage to rebuild or more coverage for the contents, whatever the case may be. After you've gone through our process, and if we're not able to assist you, and it's a claims issue, there's a statutory mediation program. That program is mandated on insurance companies. They're required to do it if we ask. So if we run into an impasse that we think we just can't resolve, let's say it's a valuation issue that we're not going to be the judge on, how much something costs to rebuild and try to close that gap or make a binding decision on that, we may suggest mediation. And if you want to go, the insurance company is mandated to go to it. And if it'll follow the same basic procedure as which was just described to you, it is free. It's free to the policyholder. The insurance company has to pay for it. So that is one benefit. The other benefit is it tolls the statute of limitations. So once we've made a determination that it's going to go to, that it should go to mediation, and if you agree that you want to take it to mediation, we'll send a letter to the insurance company letting them know that they have 28 days to settle the claim, or this is going to be assigned to a mediator to mediate the case. Once we've sent them that 28-day notice, it tolls the statute of limitations from that time until the conclusion of the mediation process. And so that's a good thing. It gives you more time to decide if you are at a true impasse such that you do need to go to litigation, but it stops the clock for a while, so you don't lose those rights. And that's really it. It basically follows the same process. We deal with scope of loss, valuation issues, that kind of thing. With underinsurance issues, it has to be agreed to by both parties. So if we're at an impasse on an underinsurance issue and we can't resolve it, then we'll ask you if you want to do mediation. But in that case, the insurance company is not mandated to go. They have a right to say no. But in past events, 2007 wildfires, for example, 2003, we've been able to get most of the major insurance companies to agree to go to mediation, even for underinsurance. And we did have some success in getting some settlements out of those mediations. So I encourage you to contact us, give us a shot. We're not going to be able to resolve every issue you bring to us. Some of them are going to be either too complex, or too many legal issues or other issues where we don't have the facts on our side to get success. But we're definitely not going to be able to help you if you don't come to us. So please do. And the last thing is, as the judge also mentioned, the more information we get, the more information we'll have to give to the legislature to determine whether we need to do a market conduct examination of an insurance company that'll look at their overall practices and how they handle these claims, which maybe can get some remediation for people, but it also will allow us to force the company to improve their claims practices over time to do better next time. And so that's what I thought.
So, I have a question for you, Tony, that Vita brought up a good one, and I thought this was a perfect time to ask you. So, we've been encouraging people to file complaints, and I said earlier on the underinsurance issue, although I have to be candid, I don't know. I mean, I think it's tough for everybody. It's tough for the department. How do the complaints that people file with you then end up helping them? That sort of like, what do you do with all the data you get about, let's say, all these people who are underinsured? Can you give some examples?
Well, in addition to trying to help their individual case, the information we get, for example, we've been testifying for the last couple of months for all these bills going through the legislature, like 8 bills going through the legislature. Big challenge getting them through. Some of them are making it, some of them aren't. And obviously, we can use community help to get these bills passed. We're on the final stretch with some of these bills. But we use a lot of that information. We're testifying at the Capitol in front of the committees to support the need for these bills and to support the idea that, you know, people need help, they need help now, and here's how they can be helped, and here's the data to back up what we're saying. And so the more information we have.
Bills are losing teeth. Not going to help others, but your chances of, if any of these bills pass, chances of helping us dwindling and dwindling and dwindling.
Okay, I'll tell you what, because I feel you. The legislative, for those of you who've been following it, there are 14 bills that were introduced to try to give some relief to your community. The insurance lobby is very, very powerful up there. Even though a number of you have come up, I've been up there, Tony's been up there, and actually, you know, Vida, through her website, has been helping facilitate. And our organization put together sample letters. We are trying to encourage everybody to make their voices heard, but the fact is, it's a super long shot. Trying to get these bills to be retroactive to help all of you was always a long shot. And I think it's not looking great right now for anything really that needy. And that is only to say, just today, right before I came here, you know, I was talking to somebody at the Press Democrat about what looks like might be happening. It's really too early to say, and I'm trying to keep this to things that are real and that are facts. So let's put that discussion about the bills off for now until we really know. But I will leave you with this. Senator Glazer, who chairs the Senate Insurance Committee, and then Assemblyman Daley in the Assembly. Those are the people you need to be writing to. Those are the people that you need to be putting pressure on. Right on the homepage of our website, you will find a link to our sample letters that you can use. We list all the bills and we give some just basic information encouraging you to make your voices heard. So, did you want to...
One last closing thing. If you didn't already see, we have a department mediation program pamphlet that we left on the table up front, so if you want to grab one, there should be enough. And if you didn't get one or it runs out, let us know. We'll get one to you. There's also a residential property claims guide. It's general, it's stuff that you've been seeing here, but it does have a request for assistance form in there to give you an idea, just a short type of questions that we need just to get the case started. You can also do it online on our website, but it's there so you can take a look at it.
Thank you, Tony. Vida, did you just want to tell us what is the URL of the website or that people should know about in the listserv?
It's neighborstogethersr.com. Neighborstogethersr.com. There are 4 listservs of insurers that I know of. State Farm, there's over 300 of us. That's the list that I run. There's
Can everybody hear her? Because I can bring you on.
State Farm, California Casualty, Hartford, and AAA just formed. I hear that there are other groups. If you all go to the website and contact me, I can post your group. If you think that there's nobody like you, or you don't know if anybody wants to start a group for your carrier, start a group. If there's a bunch of orphans, start an orphan group or reach out to me. 300 in State Farm, AAA just started. In 12 hours, there were over 45 signups. People have a lot of pain out there, I know. So neighborstogethersr.com, there's a lot of information about a variety of things. I post things about UP, the California Department of Insurance, even though I was very rude to Tony. They've been very helpful to all of us. And I list all the events that I can that are helpful for recovery, including these events, the financial planning, the legal aid, insurance clinics. So one final thing, if you don't know what a block captain is or you're interested, please come see me. Thanks.
Thank you, Vida. And again, United Policyholders is about
people working together. Vita is about that. My friends Al and Jenny Stoles are about that. They had come to us a while back saying, hey, we need to find other Cal Casualty folks. Hopefully, we were able to connect them with some. We're doing everything we can, Vita too. So again, it takes a county, not just a village. The guidance available at our website that's relevant to what we talked about tonight. Speak Up, going up the chain of command. Insurance appraisal simplified. Appraisal is another way of resolving a valuation dispute over how much it should cost to put your house back. But again, we are thinking that there could be a cheaper, better way than appraisal. But if that is something that you're interested in, you can learn about it from our website. Policyholders Guide to Mediation, hiring professional help, sample letters,